Hello guys, welcome to Sandpaper Academy for Civil Services MCQ series for APSC CCE Prelims, which is going to be held on year 2024 March হ'ব তাৰ কাৰণে আজি second to যোনটো MCQ series এটো লৈ আহিছো আপোনালোকৰ কিবা query থাকিলে sandpaperacademy@gmail.com আমাক মেইল কৰিব পাৰে আৰু if you have liked our video then please like, comment, share and subscribe our YouTube channel Sandpaper Academy for Civil Services. So আজি first question to hold, consider the following statements for Kesavananda Bharati case. So the case dealt with the petition against Kerala government challenging the compulsory acquisition of his land by government under Kerala Land Reforms Act 1963 as a violation of fundamental rights as enshrined in the Article 25, 26, 31 of the Constitution of India. Yes, this is correct. It corrected the judgment of Golaknath case and hence Supreme Court held that Article 368 contained both power and procedures for amending the Constitution and that amending powers and legislative powers of Parliament were different. This is also true. The most significant aspect of Kesavananda Bharati case was the introduction of basic structure of doctrine. So all are true here. So D option will be correct. So Kesavananda Bharati case to decide versus State of Kerala, also known as Kesavananda Bharati judgment, was a landmark decision by Supreme Court that outlined the basic structure doctrine of Indian Constitution. 13 judgments asile ekhon Supreme Court 7:6 majority decide hoisile. It upheld the validity of 24th Constitutional Amendment Act 1971 and stated that Parliament is empowered to abridge or take away any of the fundamental right. As per 24th CAA, Constitution amendment were not considered under Article 13. Okay, this amendment gave the unlimited power to the Parliament to amend or repeal any part of the Constitution of India. Okay, however, the court laid down a new doctrine, that is basic structure of the Constitution. In Kesavananda Bharati case, the court ruled that the constituent power of Parliament under 368 doesn't enable it to alter the basic structure of the Constitution. Okay, basic structure of Constitution alter koribo নোৱাৰে বুলি কলে. This means that Parliament cannot abridge or take away fundamental right that forms a part of basic structure of Constitution. এনেকুৱা fundamental right যি basic structure of Constitution mean কৰে তাৰ ভিতৰত অন্তৰ্ভুক্ত হয় সেইটো abridge কৰিব নোৱাৰে বা take away কৰিব নোৱাৰে পাৰ্লিমেন্টে। ঠিক আছে, so answer will be all of the above. Next, recently Chhattisgarh government has urged Prime Minister to enlist the amended reservation provisions of the state which provides 76% reservation in 9th schedule. In this context, which of the following statements are true about 9th schedule? 9th schedule কোন কেটা বস্তু শুদ্ধ এটো কব দিছে। It was added by Constitutional First Amendment Act 1951. This is true. First Constitution Amendment Act 1951 add কৰিছিলে. It is a special provision in Constitution of India that allows legislature to exempt certain laws from judicial review of constitutional amendment. Okay, this is true also. Okay, the 9th schedule was brought by adding a new Article 31C. This is not true. This should be 31B along with Article 31A, enacted with the aim of protecting laws related to agrarian reforms and to abolish zamindari system. So since some basic means a concept regarding certain facts are enshrined in certain articles, that so এইবিলাক কিছুমান বস্তু আপোনালোকে মনত ৰখাটো জৰুৰী। So which of the following statements are true? This is not true. 1 and 2 are true. 3 is not true. So B is correct. So 1 and 2 are correct. 9 schedules of First Amendment Act 1951 add korisile. Through First Amendment Act in response to Supreme Court's decision in Shankari Prasad case 1951, which said rule that law enacted by the Parliament could be challenged if they violated fundamental rights guaranteed by the Constitution. The 9th schedule is a special provision in Constitution of India that allows the legislature to exempt certain laws from judicial review. Judicial review পৰা legislature কিছুমান law ক্ষেত্ৰত exempt কৰে through constitutional amendment. The 9th schedule was brought by adding a new Article 31B. So along with Article 31A with the aim of protecting laws of agrarian reform and abolish zamindari system. Originally, laws included in the 9th schedule are immune to being challenged in the court on the grounds of inconsistency with the fundamental rights guaranteed by the Constitution of India. So যোনবিলাক law asile under 9th schedule প্ৰথমতে these cannot be challenged, but these are immune from being challenged asile. তাৰ পিছত কি হল in IR Kohelo case কি কলে, so this is that is not linear to basic structure of the constitution and can be challenged and subjected to judicial review. So আমি প্রথমৰ পৰা চাওঁ তিনটা কেছ ইম্পৰ্টেণ্ট এই ক্ষেত্ৰত কেশৱানন্দ ভাৰতী কেছ ভাৰ্চেছ ষ্টেট অফ কেৰালা সুপ্ৰিম কোৰ্টে ক'লে যে এনি law that violates basic structure of the constitution can be declared unconstitutional by the court. আৰু Waman Rao versus Union of India 1981 ত ক'লে this significant decision Supreme Court ruled that amendments made after 24th April 1973 in the 9th schedule can be challenged on the ground of constitutionality. So constitutionality ক্ষেত্ৰত on the grounds of যোনবিলাক amendments 24 April 1973 পিছত amendment কৰা গৈছে পিছত এইবিলাকক কি কৰিব পাৰি challenge কৰিব পাৰি on the grounds of constitutionality. So IR Kahilo versus State of Tamil Nadu 2007 at the court ruled that any law enacted under 9th schedule after 24th April 1973 must be examined under Article 14, 19 and 21. These are very important points. Furthermore, it stated that any act that is not in line of basic structure of the constitution can be challenged and subjected to the judicial review. Okay, so next আমি গৈ আছো Interstate Council of Article 263 contemplates the establishment of Interstate Council to effect coordination between the states and between center and state. Okay, this is true. The President can establish such council at any time it appears him to public interest would be served by his establishment. So this is, I think, yeah, this should be true. Yeah, true. This is true. The council meeting are supposed to be held twice a year. No, this should be held at least thrice a year. Any decisions on all questions are decided by consensus. This should be at least thrice. The standing committee of the council was set up in 1996 for continuous consultation and processing of matters for consideration of the council. So এইকেইটা যদি analyze কৰে তেতিয়াহ'লে A, B আৰু D টো correct আছে. A, B, D নহয়, actually this should be 1, 2, 3 and this is 4. So 1, 2 and 4 are correct. 1, 2 and 4 are correct. That is B is correct. Interstate Council 263. The president can establish a 2. The president is also authorized to define the nature of his duties to be performed by such council and its organization and procedure. Who is authorized? President. Okay, duty ki hoy? Inquiring into the advising upon disputes which may arise between states. Amar je bibad choli thake hima loi pele. Okay, investigation and discussing subjects in which states or the center and the states have a common interest. ঠিক আছে, য'ত যিবোৰ সাবজেক্টত states বা center আৰু stateৰ common interest আছে সেইবোৰ ক্ষেত্ৰত investigation কৰা. Making recommendation on any subject for better coordination for policy and action. Composition কেনেকুৱা? এই কাউন্সিলখনৰ PM থাকে, chairman, CM of all states থাকে, CM of UTs having legislative assembly থাকে member হিচাপে, administrator of UTs not having legislative assembly থাকে, governors of states under president's rule থাকে, 6 cabinet minister থাকে including home minister to be nominated by PM, and 5 ministers of cabinet rank are permanent invitees of the council. So this is the composition. Next question is 40 number question. The year 2023 marks 30th anniversary of 73rd Constitution Amendment Act of Indian Constitution. In this context, which of the following statements are false regarding 73rd Constitution Amendment Act? False kuntu etu hoise. It was Panchayati Raj Constitution was institutionalized by this act. Through this act, this is true. This act added Part 9 of the Indian Constitution, which consists provisions from Article 243 to 243. Oh, this is also true. This act added 12 schedule to the Constitution that had 35 items in the Panchayat. So this is not wrong. 11th, this should be 11th schedule and this should be 29 items. Misam. Okay, so 1 and 2 are correct. 1 and 2 are correct. That is D is correct. So D is correct, but the question kuntu bhul. So 3 is wrong. So that is the main trick in the UPSC paper. Kuntu false etu dise. So 3 is false. Last or kuntu asile etu false asile. Karon tat part 11th schedule সলনি বেলেগ schedule কথা উল্লেখ আছে 29 subject সলনি 31 subjects কৰি দিয়া গৈছে so 1993 পৰা আছে it's a landmark piece of legislation that introduced democratic decentralization in India. Panchayati Raj was constitutionalized. Part 9 to add কৰিছিলে আৰু 11 schedule আৰু 29 functional items panchayator under আনিছিলে ঠিক আছে তেনেদৰে 74th constitutional amendment act to তাৰ লগতে আছিলে ইয়াত আকৌ দিছে which are true এবাৰ true খিনি ক'ব লাগে urban local governments were constitutionalized by this act yes it added part 10 and consists of provisions from article 243p to 243zg this is also true it also added 12th schedule no this is not true this should be part 9a 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 বাকিখিনি ঠিকে আছে part 9a হ'ব লাগে okay so this also added 12 schedule to the constitution and contains 18 functional items for municipality so 1 and 3 are correct but true কোন কেইটা হৈছে 1 and 3 correct হয় okay 1 and 3 are correct so আপোনালোকে চাব পাৰে this is part 9a part 9a বাকিখিনি ঠিকে আছে also added 12 schedule to the constitution that contains 18 functional items for municipalities next which of the following criteria are true regarding getting of the status of national party so a party should national party hobo karone ki lagibo a party should secure at least 10% of vote polled in 4 or more states in Lok Sabha or assembly election and in addition at least have 4 members in Lok Sabha this is piece of part to theke ase this should be it should be 6% this should be 6% okay so this is false it should have at least 5% of Lok Sabha seats and have candidates from not less than 3 states so this is also not true because this should be 2% and last to ki koise it must be a state party in at least 4 states this is true so 1 and 3 are not correct it means true kuntu bisaribo dise 3 is correct so c 3 is correct 3 only as a party should at least 6% of both secure কৰিব লাগিব বুলি ক'লে আৰু at least এটো 2% of total Lok Sabha seats বাকিখিনি সব ঠিকে আছে next আহি গ'ল which of the following is true regarding impeachment of president of India the ground of impeachment should be violation of the constitution this is correct impeachment charges can be initiated by either house of the parliament either in Lok Sabha or Rajya Sabha this is correct it requires 2/3 majority from both of the house this is also true so all are correct here so answer will be D so impeachment of the president article 61 procedure for impeachment of president was mentioned in the constitution the president can be removed from his office through a process of impeachment for violation of constitution impeachment proceedings can be initiated by either house of the parliament with charges being signed by 1/4 member of the house so this is very important piece of part খিনিও কেতিয়াবা full question to MCQ হিচাপে দিব পাৰে 1/4 মানে 2/3 okay the president is given 14 days notice okay so যদি notice দিয়া হয় before proceedings begin and he has the right to appear and be presented during the investigation if a resolution is passed by 2/3 majority of both houses president is removed from the office so this resolution should be accepted by 2/3 majority of both of the houses okay and impeachment is a semi judicial process in parliament nominated members parene bhag lobo karone nominated members in either house of the parliament can participate in impeachment proceedings even though they cannot vote in presidential election very important যদিও nominated member presidential election on take part কৰিব নোৱাৰে কিন্তু তেওঁলোকে impeachment proceeding on ভাগ ল'ব পাৰে members of state legislative assemblies and UTs of Delhi and Puducherry who can vote in the presidential election do not participate in impeachment proceedings this is also an interesting fact যিসকলে আকৌ participate কৰে যেনেকে members of LS বা UTs of Delhi and Puducherry তেওঁলোকে ভোট দিব পাৰে in presidential election মানে যেতিয়া appointmentor ক্ষেত্ৰত কিন্তু impeachment proceeding তেওঁলোকে ভোট দিব নোৱাৰে বা participate কৰিব নোৱাৰে okay next which of the following statements are true about Lokpal and Lokayukta Lokpal and Lokayukta Act 2013 provided for establishment of Lokpal for union and Lokayukta for states this is true these institutional statutory bodies without any constitutional status this is also true They perform the function of ombudsman and inquire into allegation of corruption against certain public functionaries and for related matters. এইটো শুদ্ধ। Lokpal and Lokayukta Amendment Act 2016 যোনখন আছে, it allows this amendment এটা আহিছিলে বুজিছেনে? It allows the leader and the largest opposition party of Lok Sabha, in absence of a recognized leader of opposition, to be a member of selection committee that choose ombudsman. This is also true. In case of absence of recognized leader of opposition, member of মানে কি কয় এইটো, it allows the leader of the largest opposition party to allow করে যেতিয়া মানে absence of recognized leader of opposition absent থাকে, ঠিক আছে? So 1 2 3 4 all are correct. So answer will be C. Answer will be C. Lokpal and Lokayukta bill received presidential assent in 1st January 2014, came into force 16 January 2014. It's a multi-membered body, consists of one chairperson and maximum of 8 members. এইবিলাক important note কৰি যাব। Chairperson of the Lokpal can be either from the Chief Justice of India or former judge of the Supreme Court, and or an eminent person with an impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. This is also very important thing. Chairperson জন qualification কেনেকুৱা হ'ব লাগে, তেওঁ ক'ৰ পৰা নিৰ্বাচন কৰা হয়, etc. Out of the maximum 8 members, half will be judicial members and minimum 50% of the member will be from SC, ST, OBC, minorities and women. So this is also important. Note কৰিব, prelims ত কেতিয়াবা আহি যাব পাৰে। The judicial member of Lokpal either for a former judge of the Supreme Court or from a former Chief Justice of a High Court. Okay, judicial member জন কি হ'ব? Either former judge of the Supreme Court হ'ব লাগিব, নহলে former Chief Justice of a High Court হ'ব লাগিব, ঠিক আছে? A non-judicial member should be an eminent person with a impeccable integrity and outstanding ability, having special knowledge. এইখিনি একেই থাকিব non-judicial member খিনি, member জন। The term of office of the Lokpal chairman and members are 5 years or till the age of 70, not 65. ভুল কৰে বহুতে। The members are appointed by president on recommendation of selection committee. এই selection committee টোৰ কথাই লাষ্টৰ D পইণ্টটোত কোৱা হৈছে। So initially the selection committee is composed of prime minister, who is the chairperson, speaker of Lok Sabha, leader of opposition in Lok Sabha. So নাথাকিলে largest majority থকা opposition party জনে selection committee আহিব পাৰে। Chief Justice of India or a judge nominated by him or her, and one eminent jurist. For selecting chairpersons and a member, the selection committee constitutes a search panel for at least 8 persons. So these all are about Lokpal and Lokayukta. So amendment এখন আহিছিল 2016 ত, এটো চাই ল'ব। This amendment changes this act, Lokpal and Lokpal Act, which regard to the reporting of assets and liabilities by public officials. So এটা কি কৰিলে, reporting of assets and liabilities by public officials to মানে amend কৰিছিলে। It allows the leader of the largest party of Lok Sabha, in his absence of a recognized leader of opposition. So it allows the leader of largest opposition party, largest যোনটো opposition party আছে Lok Sabha, তেওঁ instead of leader of opposition, যদি absent থাকে leader of opposition, to be a member of selection committee হ'ব পাৰে বুলি কৈছে, যিজনে ombudsman choose কৰিব পাৰে সেই কমিটিখনে। তো selection committee ombudsman choice কৰে আৰু তাতে চেয়াৰমেন হিচাপে PM থাকে আৰু বাকীসকল মেম্বাৰ আগৰ স্লাইডটোত আপোনালোকে দেখিলে তাতে কি মেনশ্যন আছিলে, লিডাৰ অফ অপজিশ্যন আছিল। আৰু যদি লিডাৰ অফ অপজিশ্যন নাথাকে তেতিয়া কি কৰিব পাৰে, leader of largest opposition party in Lok Sabha can be a member of that committee. So the bill modifies section 44 of this act, which originally dealt with requirement of public officials to report their assets and liability within 30 days of the starting of their government service. The amendment eliminates 30-day frame in the section 44, and public officials will report their assets and liability as outlined by the government. Government outline কৰাৰ দৰে ধৰণেৰে কৰিব লাগিব এতিয়া। Okay, 30 days time frame to eliminate কৰি দিছে। এইটো এটা important point। এই দুটা point আপোনালোকে মনত ৰাখিব এইখন amendment, ঠিক আছে? So next I go Goods and Service Tax Council recently accepted group of ministers recommendation on long pending constitution of GST Appellate Tribunal in the country. GST বুলি যোনটো কোৱা গৈছে। In this context, which of the following is true about GST Appellate Tribunal? GST Council কথা শুনা নাই। The President, as per Articles 279A1 of the amended Constitution, mandates for constitution of GST and its branches. This is not true. This is for GST Council. এইটো চেন্ট্ৰেল এটা এক্ট আছে মই আপোনালোকক নেক্সট পেজটোত কৈ আছো the GST will be specialized appellate authority so ইয়াতে 112 বুলি এটা সেকশনো আছে এইটো ওপৰটোত তো আমি পঢ়িম একখনৰ কথা will be a specialized appellate authority for resolving disputes under GST laws this is true the GST will have one principal bench in New Delhi and as many benches or boards in state as decided by each state subject to the approval of the council so 2 and 3 are correct 1 is not correct okay so 1 2 ক্ষেত্ৰত কি হ'ব so a Central Goods and Service Tax Act 2017 in section 12 it mandates for the constitution of GST and its benches okay so benches বিলাকৰ কথা যদি কয় principal bench consist of president judicial member technical member থাকিব center technical member এজন থাকিব state located হ'ব এটো Delhi the only principal bench shall hear the cases involving the issues of the places of supply so this is important state benchত কি থাকিব consist of two judicial members a technical member center পৰা এজন state member these are established on the request of the state and the recommendation of GST Council okay so last ami ahisu which of the following is true about Cinematograph Amendment Bill 2023 the bill introduced by Ministry of Information and Broadcasting seeks to amend the Cinematograph Act 1952 which authorizes CBFC by Central Board of Film Certification to require cuts in the films and clear them for exhibition in cinemas and on television this is true bill substitutes UA category with the following three categories to also indicate age appropriateness. So age appropriateness keneke hobo okol UA likhile nohobo tintar kotha koa goise UA 7 plus UA 13 plus UA 16 plus this is also true. Films with A or S certificate will require separate certificate for exhibition on television or any other media prescribed by the central government this is also true. The bill prohibits carrying out or editing the unauthorized recording or unauthorized exhibition of films in order to stop piracy. So unauthorized editing ba carrying no hobo boli koise. So all are correct here. All are correct here. So all of Sino Lok Sabha and Rajya Sabha passed Cinematograph Amendment Bill 2023. It expands the scope of law from the censorship and also to cover copyright and introduce stringent anti-piracy provisions. So it aims to amend existing Cinematograph Act 1952. So yet as a one point, the bills aims to deter piracy of films by imposing strict penalty on individual involved in unauthorized audiovisual recording and distribution of copyright content. Okay, so include hobo lage etu actually d eta thaki hoise imprisonment hobo pare 3 mahor pra 3 bochor leke from 3 lakhs to 5% of the audited gross product cost fine hobo pare thik ase aru I ki korise aims to extend the coverage of the previous act which was primarily focused on censorship to now encompass copyright protection so it emphasizes autonomy of CBFC this is very important autonomy CBFC diar kotha koise the government may no longer have revisional powers over CBFC's decision based on Supreme Court judgment in case of KM Shankarappa versus Union of India okay the amendment bill introduces a new age rating system for films that require adult supervision. The current UA rating, which covers a broad age range, will be split into 3 different categories. Junto mention korise UA 7, UA 13, and UA 16 plus. But get a plus. UA 7 plus ki hoje films suitable for children above 7 age with parental guidance. Aru 13 with parental guidance. Aru suitable for children above 16 with parental guidance. ठीक है This new classification system align with the graded age classification implemented for streaming platforms under the IT rules 2021 and the Sham Benegal committee recommendations of 2017 are the important points I know the bill will allow firms to be rectified for television and other media the act has been amended to remove 10-year validity restriction of CBFC certificates, thereby granting them perpetual validity. So these all are important facts. I hope apnaloke answer koribo parise. So if you have liked our video, then please like, comment, share, and subscribe our YouTube channel, Sandpaper Academy for Civil Services. Akolo him adu 10 questions for current affairs, APSC Prelims into ahi ase 2024. এইবাৰ ক্ৰেক কৰিব লাগিব। যিসকলে এতিয়াও প্ৰিপাৰেচন কৰা নাই তেওঁলোকৰ কাৰণে সময় বহুত কম আছে। যিসকলে আজি কুৱেশ্যনবিলাক কৰিব পাৰিছে তেওঁলোকৰ অল দ্য বেষ্ট, আৰু যিসকলৰ এটা দুটা অলপ পৰা নাই তেওঁলোকে আৰু অলপ ব্ৰাছ আপ কৰিব লাগিব। চ' গুড বাই এণ্ড হেভ এ নাইচ ডে। থেংক ইউ।